I want to get going into today's events because, as Frank pointed out, we have two great panels. And, of course, as you know, what we're talking about here, the title is Under the Gun, Reporting News in a Dangerous World. And the first panel is the growing censorship of free speech. And Frank alluded to that. But let me begin with a quote and a couple of statistics before I ask our panelists to come forward, because I think they kind of set the stage for what we're trying to talk about today with increasing difficulty. This is from the World Press Freedom Index for 2011 and 2012. It comes from Reporters Without Borders. And they say this: crackdown was the word of the year in 2011. Never has freedom of information been so closely associated with democracy. Never have journalists, through their reporting, vexed the enemies of freedom so much. Never have acts of censorship and physical attacks on journalists seemed so numerous. The equation is simple. The absence of suppression of civil liberties leads necessarily to the suppression of media freedom. Dictatorships fear and ban information, especially when it may undermine them. And then they follow that up with some fairly chilling statistics. In 2012, or 2011, I should say, the number of journalists killed around the world increased 16%. The number of journalists arrested increased 95%. The number of journalists attacked or threatened increased 43%. And here's one that I find particularly troubling. Countries affected by censorship increased by 10%. Now, they've got 10 of the most dangerous places in the world for journalists. Not surprisingly, 6 of them are in what we would term the Middle East, and 2 of them are what we would call the Arab Spring, specifically Tahrir Square in Cairo and Misrata in Libya. But I think this morning what we're going to find is just as problems are affecting journalists or people who try to speak the truth over there, so are they beginning to affect people who try to speak the truth here. And that is why we're very pleased to welcome 3 very distinguished people to talk about growing censorship in America. Let me begin with Brooke Goldstein, who many of you know, but just so you know, the most important thing you need to know about Brooke Goldstein right now is her book is on sale in the lobby. If you have not read Lawfare, you need to do it. It is a short read, it is a compelling read, and it is an important read now because it talks about how journalists can speak truthfully about national security threats, even though sometimes they do so at their peril. If you don't know Brooke, you can probably find her on Fox News. She's been featured in several media outlets such as CNN, the New York Sun, Defense Technology International, and on ABC News Talk Radio. She is a New York-based human rights attorney, the author and award-winning filmmaker, and is currently the director of the Lawfare Project, a nonprofit organization dedicated to raising awareness about and facilitating a response to the abuse of Western legal systems and human rights laws. What I'm going to do is ask all of our panelists to come forward, speak for about 10 minutes, then take a seat here at the podium. When they're all done, we'll open it up for any and all questions that you have. But please welcome to our podium right now, Brooke Goldstein.
Thank you so much, Fred, and of course, Christine, Tracy, Dave, and Frank. I'm so grateful to be here, to be given the opportunity to address you. This is a wonderful event, and I'm really honored to be included amongst the distinguished panelists. So just cut me off when I've reached my 10 minutes, but this is an issue that's very close to my heart, and it all started when I was in my 2nd year of law school, and I just happened to be taking a class on human rights and the child, and we were learning about the Convention on the Rights of the Child and the UN Charter and all the lofty principles contained therein. Every child has a right to life. Every child has the right to an education and media free of incitement to hate and to kill him or herself. And I came home one day and I turned on the TV. And before me was broadcast the image of a 15-year-old, physically handicapped, rumored to be mentally handicapped Palestinian boy with live explosives strapped around his waist and his hands in the air. He was caught at the Hawara checkpoint, and he gave himself up before he was supposed to detonate amongst the Palestinians waiting in line. And I thought this was such a compelling, moving scene about the root causes of terrorism that I took it upon myself over a period of 2 years, and at the risk of my life, to travel in and out of the West Bank. I secured interviews with leaders of terrorist organizations and families of suicide bombers, and I released the movie, The Making of a Martyr. And I was very fortunate. The film ended up getting the Audience Choice Award for Best Film at the United Nations, and because of that stamp of approval, I traveled around the world to various film festivals, and my movie got press, and I started going on Fox News, and I started going on CNN, and my op-ed started getting published. And my message was very, very simple. Muslim children are innocent. They don't deserve to be taught to hate and to kill themselves. And the militant Islamists who are recruiting and indoctrinating innocent Muslim children to blow their limbs to pieces are engaged in a form of child abuse. And yet I realized the more that I started speaking out about these issues, everybody who was doing the same thing that I was doing, anyone who was brave enough to speak publicly or to write about the real and imminent threat that Islamist terrorism is, started getting sued. For example, in Europe and in Canada, dozens of hate speech and libel lawsuits were filed against counterterrorism experts, against think tankers, against members of the media. Just to name a few examples, in 2002, the Saudi Al Rahajdi Bank filed a lawsuit against the Wall Street Journal Europe for reporting on the fact that the Saudis' bank accounts were being monitored for alleged ties to terrorism. In 2005, I'm sure many of you are familiar with the lawsuit that was filed by the now deceased Saudi billionaire Khalid bin Mahfouz against Rachel Ehrenfeld for her book Funding Evil, which linked bin Mahfouz to funding terrorist organizations. In 2006, the founder of the Islamic Supreme Council of Canada filed a complaint against Ezra Levant for publishing or republishing the now infamous Danish cartoons of Muhammad in the defunct Western Standard magazine. In 2007, the Canadian Islamic Congress filed a similar complaint in Canada against Mark Steyn for his book America Alone, which simply went into demographics of the Muslim community. It talked about numbers, and yet he was accused of writing a book that was offensive to the Muslim population in Canada. In 2009, a lawsuit was initiated in Denmark by a Saudi law firm against the newspaper Politiken on behalf of 94,000 claimed descendants of Muhammad, also for republishing the cartoon of Muhammad with a bomb in his turban. And in 2009, a trust that managed the North London Central Mosque sued the think tank Policy Exchange because they had sent someone undercover into the mosque bookshop. They translated the books that were being sold, and they said that they were inciting violence. And of course, last year, an Austrian appellate court upheld a conviction against an Austrian citizen, Elisabeth Sabadich-Wolf, for, quote, denigrating the religious beliefs of Muslims after she merely presented an educational seminar about the threat of militant Islam. Now, despite the fact that we have the First Amendment here in the United States, we have seen a steady increase in the filing of very similar frivolous lawsuits in this country, and the goal is to silence and punish and intimidate anyone who, like many people in this room, are brave enough to raise awareness about real threats. In 2001, the now designated terrorist organization, the Global Relief Foundation, sued a number of media defendants, including the New York Times, ABC, the Associated Press, for publishing articles about the fact that the Global Relief Foundation was under federal investigation for alleged ties to terrorist organizations, that the charity might have its assets frozen as a result. In 2005, the Islamic Society of Boston sued more than a dozen defendants, including the local Fox News affiliate, the Boston Herald, and Stephen Emerson, for merely raising awareness about the fact that Saudi funds were going towards building an Islamic center and mosque in Boston. In 2007, Joe Kaufman, an American citizen and activist, was sued by 7 Dallas area Islamic organizations for staging a lawful, peaceful 10-person protest against the Islamic Circle of North America, which he called a radical Muslim organization that has physical ties to the Muslim Brotherhood and financial ties to Hamas. And in 2008, and my colleague Sam is going to talk about this a little bit more, Hassan Dar al-Islam, an Iranian American who fled Iran because he was being persecuted there, whose family is still being persecuted in Iran, came here to the United States because he thought he could write and speak freely about issues that were close to his heart. And yet he published an article calling NIAC, the National Iranian American Council, a lobbying arm on behalf of the Iranian government. And he's now engaged in, I think, the 3rd year of defending himself. And one of the scariest ongoing suits is that of Bruce Teft, a former counterterrorism advisor to the NYPD, who is currently being sued by a Muslim John Doe police officer for workplace harassment because the police officer was personally offended by emails containing articles about the threat of Islamist terrorism that Bruce Teft sent out to police officers after 9/11. Now, the majority of these type of lawfare lawsuits, and by lawfare we mean the use of the law as a weapon of war, are either thrown out of court because there's absolutely no merit to them, or they're dropped right before the discovery process. Because what happens during the discovery process? If I accuse XYZ organization of funding a terrorist group, during the discovery process, I get to discover the financial records of that organization that would go to prove the truth of the matters that I assert. But whether or not the victim of lawfare wins the case in the end, they still lose in money, in time and money spent defending their rights, and this has created a very detrimental, chilling effect and has raised the cost of open dialogue about terrorism. Now, one of the greatest proponents of lawfare against free speech is CAIR, the Council on American Islamic Relations, a self-appointed representative of the Muslim community with a very generous presence on the Hill. CAIR is one of the unindicted co-conspirators in the Holy Land Foundation trial. Holy Land Foundation was taken down after 9/11 because it was a terror financing front. CAIR was founded by the same individuals as the Holy Land Foundation. It is currently a tax-exempt 501c3 organization in the United States. In 2003, CAIR sued former Congressman Cass Ballinger for reporting to the FBI that CAIR was, quote, a fundraising arm for Hezbollah. The judge threw that out of, Now, over the last few weeks, CAIR has called for the resignation of NYPD Commissioner Ray Kelly because he appeared in the recent film, The Third Jihad, about the threat of Islamist terrorism. In the meantime, the New York Times has labeled the NYPD Islamophobic for using the film to teach police the difference between Islam as a personal faith and Islamism, which is the militant and political arm of Islamist terrorism. And in 2001, CAIR filed a class action suit alleging that the FBI was conducting illegal surveillance of the Muslim community, while at the same time they were trying to hamper federal investigations by printing and distributing flyers that said, "Build a wall of resistance, don't talk to the FBI." And finally, in testimony to the Committee on Homeland Security, the director of the Somali Education and Social Advocacy Center in Minneapolis identified CAIR as deliberately impeding the Somali Americans community attempt to discover the whereabouts of children who had been kidnapped by terrorist groups like Al-Qaeda and were being trained abroad to become child suicide bombers. Now, what's happening right now is extremely scary, and Frank had mentioned the Istanbul process. At the international level, over the past 10 years, the Organization of the Islamic Cooperation, a 57-member voting bloc at the UN, it has hijacked the General Assembly, it has hijacked the Human Rights Council, has successfully passed resolutions attempting to outlaw the defamation of Islam, i.e. blasphemy, as a crime against humanity in international customary law. This past December, Hillary Clinton hosted the OIC in a 2-day closed-door meeting. The press were not allowed to implement the latest series of those resolutions, Human Rights Council Resolution 1618. And what has resulted, and I'm sure Mr. McCarthy will talk about this, is a top-down review by the Obama administration of all counterterrorism training manuals. They're redacting the word Islam, they're redacting the word jihad from it, and an actual blacklist of FBI officials, of counterterrorism experts who are now no longer able to teach at National Defense University or to brief our police officers because their speeches or their educational seminars are deemed Islamophobic. So I thank CSP for their courage in raising awareness about this issue, for their extreme generosity with their grant that enabled the book Lawfare, The War Against Free Speech to be published, which is a very succinct, I hope, primer on the First Amendment that we published to encourage people to continue exercising their rights to speak freely about these issues. Thank you so much.
So much material, so little time. I think if you're not already working on a sequel to Lawfare, you probably should. But again, if you want to learn more, a lot of that is in that book. Let's continue on. It's a great privilege to welcome back somebody you know very well. As a matter of fact, when we were talking about introductions, Andy McCarthy said, what can you not say about me that hasn't been whispered by all my opponents? But just in case you don't know, another core text in the course against civilization jihad is his book, Grand Jihad, and of course, Willful Blindness. You can read him regularly at National Review Online, and of course, you know he successfully prosecuted Sheikh Abdul Rahman as the terrorist responsible for the 1993 World Trade Center. He is a great friend of the Center for Security Policy. I don't know what we'd do without him, but fortunately, we don't have to worry. Let's welcome Andy McCarthy.
Well, thank you so much, Fred. Thank you, Frank, and to the Center for putting on this event every year. Some years when I come here, I even get stuff, so that's kind of cool. I also want to be, in keeping with the zeitgeist, I feel I should begin with an apology. So I do hope that what I'm about to say is profoundly offensive to President Karzai of Afghanistan. But, you know, I think the interesting thing about the panel that we're having this morning is that in a way, we've almost bought into the other side's framework. Lawfare, the bottom line assumption of lawfare, is that legal processes can be used just like offensive weapons on the battlefield to conduct the jihad. And I think part of the reason we fall into that a bit is that we really have become an overly litigious society in which legal processes are always in the front of our minds. All the things that Brooke just talked about, which are extremely important, have the same thread about them. You notice you didn't hear her speak about, you know, a newly developed legal principle that's arisen out of these cases, a difference in the jurisprudence of the First Amendment. We haven't heard anything like that. The one thread that runs through all of it is intimidation. Much of the time, probably a great majority of the time when these lawsuits get filed, the people filing them know that they're frivolous lawsuits. They bring them because of the pressure that it puts, the intimidating, the interorum effect that it has on the people who are on the receiving ends of these lawsuits. And it's not just a legal chapter or a legal development that we ought to think about this in terms of. I think we need to think about it in terms of what is the jihad? What is the threat against us? Frank, and Frank's mentioned many times, Fred mentioned before that I prosecuted the blind sheikh and the knuckleheads who wanted to blow up the World Trade Center in 1993, nearly did, and then tried to blow up the tunnels between New Jersey and Manhattan. One of the big problems I think that we still have is that the threat to us came to us as terrorism. And for that reason, terrorism, of course, remains at the front of our minds. But I think sometimes the myopic fear of terrorism blinds us to the broader threat that we're under, of which lawfare is just one item on the menu. We came to see and understand Islamist ideology through the prism of people like the Blind Sheikh and organizations like Al-Qaeda. They are blunt instruments. They are flat-out extortionate terrorist organizations that want to bludgeon you into accepting their worldview, and specifically into accepting Sharia, which is the Islamic legal and political system. I think, unfortunately, if you listen to enough people in our government, you think that they are the entirety of the threat, and the official view of them is that they really don't have all that much to do with Islam. It's as if they were conducting this violence irrationally. But I think what everybody here needs to understand is that there's nothing irrational about terrorist violence any more than there is anything irrational about lawfare or the other ways in which this threat is furthered. The purpose of jihad is always and everywhere the implementation of Sharia law. You hear Islamic apologists say all the time, well, it says here in the Quran that there can be no compulsion in matters of religion. Not so fast. You have to read the fine print on that one. Yes, they are not talking about bludgeoning you into converting into a Muslim. In fact, if you understand Islamic law, there's an assumption that there will be a lot of non-Muslims because they pay a poll tax, and that goes to the economic viability of the state. But what they will force you into, what they will intimidate you into, what they will coerce or bludgeon you into, is acceptance of Sharia, which is the Islamic legal and political system. And whether the campaign is advanced by terrorism, or whether it's advanced by lawfare, or whether it's advanced by any of the dozens of other means, it's always and everywhere about advancing, implanting, and furthering the Sharia agenda. And that's what lawfare is about. And what I think we need to understand is that the more sophisticated terrorist organizations, or I should say Islamist organizations, organizations like the Muslim Brotherhood, which is the most important of the Islamist organizations, for them, terrorism isn't the totality of their arsenal. It's one item on the menu. So, for example, Hamas is the Muslim Brotherhood's branch in the Palestinian territories, and they are a terrorist organization. But most of the organizations that are affiliated with the Muslim Brotherhood that we deal with day in and day out, Brooke mentioned CARE, there are probably at least a couple of dozen others, but they're mostly nonviolent organizations, and they are carrying the teachings of the founders of the Muslim Brotherhood, which is to advance the cause, advance the jihad, advance the implementation of Sharia with whatever works. And if you're in a field where terrorism is the best tool, then you use terrorism. If you're in a place like America, which is obsessed with legal processes, then lawfare is the perfect item on the menu. But understand that wherever they go and wherever they operate, they are feeling for the weaknesses in a society and trying to use those to their advantage. And what they've done here is not only infiltrate our legal system, they are, much like the left's ideology works, they are trying to march through our institutions. And probably as successful and threatening as anything they've done is their ability to infiltrate, right now, the agencies of government. And this is not an Obama administration problem. I don't mean to have this be a partisan attack. This is a problem that goes back at least 3 administrations. and agencies which have been controlled by both parties. But you have people who are either sympathetic to the Islamist cause or who are Islamists themselves, who are inside the councils of government making policy. Frank talked before about Director Mueller meeting with Islamist organizations and agreeing to purge materials that they consider in bad taste. In 1993, when I had materials that were considered in bad taste, we called that evidence. They've now purged it from the FBI's training materials. I think much more of a problem for us than just how legal cases come out is when the coercive power of government is used to intimidate people from speaking. Remember, the First Amendment is supposed to be our protection against abusive, arbitrary, adhesive government action, including our ability to speak freely. But now we have agents of the government who, if they cannot use actual legal means, if they can't arrest you or bring you in and prosecute you for a case, are using what Secretary Clinton has called good old shaming. They are using their prestige as a government, they're using their coercive power as a government in order to discourage and ultimately extinguish the only thing that we have that can really protect ourselves from the threat, which is the ability to speak about it, to study it, to examine it, and to expose it. And what I would stress to all of you here is that ultimately we're not a legal society. We're not a body legal, we're a body politic. We are a political society at the end of the day. And these tactics are working because we're allowing them to work, not because they'll succeed in the courtroom, but because we're not taking a good hard look at using electoral processes and using the political means that are still available to us to make this a political issue, to make keeping America to be the America that we want it to be, making that the top political issue, and removing people or not electing people in the first place who are not part of that agenda. If they're not about protecting America from the threat that we face, then they need to be removed. And they're not going to be removed in court cases. They have to be removed by us. Thank you.
Thank you, Andy. As usual, a great report and a lot to talk about. I hope questions are forming in your mind right now. But before we get to questions, I do want to welcome up to the podium Sam Nunberg, who is currently the director of the Legal Project at the Middle East Forum, a great ally of the Center. He has served as Deputy Director of Government Affairs for the American Center of Law and Justice, as well as a delegate to the UN for the European Center of Law and Justice in Manhattan. And in that capacity, worked on legal and policy measures concerning the State of Israel, the ICC, promoting sanctions against Iran, international human rights, and First Amendment jurisprudence. He told me this morning he is also working as a political consultant. I'll let him elaborate on that if he wants, but please give a nice hand to Sam Nunberg.
Thank you. We have to, we're cut on time, so I'll get through this as fast as possible. But I want to start by thanking the Center for Security Policy for inviting me to speak on this distinguished panel. It's truly an honor, and I appreciate this opportunity, and it's good to see good friends like Deborah Burlingame here. It's nice to see you. I serve as the director of the Legal Project, which is an activity of the Middle East Forum, a think tank founded by Dr. Daniel Pipes in 1994 to promote American interests vis-a-vis the Middle East. From a litigation point of view, the Legal Project's work focuses on facilitating and advising in the defense of researchers and analysts to work on the topics of terrorism, terrorist funding, and radical Islam, who become victims of predatory lawsuits by the radical Islamist organizations that were their very subjects. The Islamists who bring these suits are not interested in winning. Rather, the Islamists seek to use the court as a weapon of legal jihad, to bankrupt, intimidate, and demoralize the defendants. Even when our clients win their cases, typically by the plaintiff Islamists dropping the matter rather than abide the discovery request, The victory comes at both great financial and time cost to the defendant, not to mention the emotional pain and suffering of being subject to a tedious, frivolous, yet aggressive lawsuit. And even though the majority of these suits by the Islamists have either been dropped or dismissed, they still have had an impact. Any author, researcher, or professor intending to publish a counter-Islamist work product must use due diligence before publication and assessing the risk of litigation. Not only does this impact the individual seeking to publish his work, but society at large, as it's almost impossible to calculate what legal jihad has cost the public in terms of both knowledge and safety. One example, which Brooke alluded to, of lawfare is the matter of Nayak and Trita Parsi versus Saeed Hassan. Since 2007, Hassan has exposed through articles the National Iranian American Council and its president Trita Parsi's deep ties and direct strategic discussions with the Iranian regime. During the last decade, Parsi has publicly played the role of habitual apologist for the regime in Capitol Hill, Foggy Bottom, and Turtle Bay. Through numerous publications and interviews with mainstream media outlets, Parsi and Nayak as a whole have continually called for direct negotiations between the U.S. and Iran, argued against sanctions to stop Iran's drive for a nuclear weapon, and of course publicly opposed the last resort of military action by either America or Israel on Iran's nuclear installations. Hassan's initial 2007 expose documented the repeated and systemic contact and coordination between Nayak, through Parsi, and the Iranian UN mission. That's 5 blocks away from here. He also showed Nayak was funded directly by the Iranians with deep ties to the regime. In 2008, Nayak and Parsi individually filed a defamation lawsuit against Hassan. The case is still ongoing, as Brooke alluded to, into 2012. Yet the discovery process has confirmed that Hassan's initial expose of Nayak's deep relation to the Iranian regime, with continuous emails between Parsi and the Iranian ambassador to the UN, reporting private conversations with State Department officials, congressmen, and the forwarding of linked information from Nayak to Iran. While Parsi and Nayak's diplomatic approach was popular with the elite during the Bush administration, incidentally when Iran was killing our troops in both Iraq and Afghanistan, he has lost much credibility these last years for continuing to defend the Iranian regime's continued provocative behavior during the Obama administration, most notably in defending the regime's atrocities during the failed Green Revolution. Yet in late January, Parsi released yet another pro-Iran apologetic book titled, quote, A Single Roll of the Dice, Obama's Diplomacy with Iran, which provides a self-described, quote, definitive and comprehensive analysis of the Obama administration's early diplomatic outreach to Iran and discusses the best way to move forward toward more positive relations between the two discordant states. On February 14th, Parsi's book was featured on Huffington Post, along with a video interview where he states that any military action against Iran's nuclear network is, quote, idiotic. Ironically, also on February 14th, Parsi's attorney, at least his third, withdrew from the defamation case against Hassan because he was disbarred. Yet while Parsi makes the media outing his book and dangerous agenda, Hassan continues to wither under Parsi's predatory lawsuit. Predatory lawsuits like this one are unfortunately only one aspect of the Islamist threat of lawfare that we face on our constitutionally protected rights of freedom of speech here domestically. The First Amendment of the United States Constitution is quite clear that Congress shall make no law abridging the freedom of speech. In New York Times v. Sullivan, the court stated that this free speech protection of the First Amendment is, quote, uninhibited, robust, and wide open. Only several narrow categories of speech are exempted from constitutional protection, including fighting words, defamatory falsehoods, and obscene materials. The court explained in Chaplinsky v. New Hampshire that these forms of speech fall outside the scope of the First Amendment protection because they are, quote, of such slight value as step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. Yet when it comes to insulting Islam through burning the Quran, we shall see through the comments of both Justice Ruth Bader Ginsburg and Stephen Breyer that the liberal activist wing is certainly open to crafting legal rationales which will create privileged First Amendment prohibitions that will criminalize insulting Islam. While this will never satisfy the OIC, these decisions will certainly be in the vein of blasphemy. On February 1st, Ginsburg, while on a State Department trip to, quote, listen and learn with her Egyptian counterparts, i.e. the Muslim Brotherhood, as they begin Egypt's constitutional transition to democracy, advised the Egyptian government in a televised interview to use the Constitution of South Africa as the blueprint in drafting Egypt's constitution because it was, quote, a deliberate attempt to have a fundamental instrument of government that embraced basic human rights, had an independent judiciary. It really is, I think, a great piece of work that was done. She concluded by adding that South Africa's constitution is, quote, much more recent than the U.S. Constitution. It is disturbing that a justice of the United States Supreme Court who was sworn to uphold the Constitution would make an implication that the United States Constitution is antiquated, no less in a foreign country. But it's also equally disconcerting that Justice Ginsburg would give preference to the Constitution of South Africa, which contains a prohibition against hate speech towards a religion. Unlike Europe, the U.S. does not have any prohibition against hate speech, as it could not survive honest constitutional scrutiny. But in 2010, Justice Stephen Breyer expressed doubts to ABC News that the First Amendment allows the public burning of a Quran because, quote, you cannot shout fire in an open theater. I'm not arguing that the Quran shouldn't be burned. It's despicable, it's intolerable, and it's morally indefensible. Yet is it any different from burning a cross or the American flag? In the 2003 decision of Virginia v. Black, the court found that Virginia's statute against cross burning is unconstitutional, and the only possible limitation against burning a cross could be when it is done to intimidate. Further, in the 1989 Texas v. Johnson ruling, the court said that burning the American flag is a form of constitutionally protected First Amendment speech. Yet burning a cross or the American flag do not upset Islamic sensibilities, which I fear the court will eventually give special deference to should Obama replace one of the four originalists on the bench. After all, as my fellow panelist Andy McCarthy exposed, Obama's cherished appointee Elena Kagan as Harvard Law School dean, quote, became the champion of Sharia, end quote, when she supported Harvard's acceptance of $20 million from Saudi Prince Alwad bin Talal, who blamed the attacks of 9/11 on American foreign policy and was then funding programs at Harvard on Islam. Yet the burning of the Quran has now become a national security issue through the actions of the Obama administration. Terry Jones, a single pastor of a small church with an almost non-existent congregation, caused such an international uproar in the summer of 2010 that according to the OIC's recent Islamophobia report, he faced, quote, widespread condemnation from the U.S. political and religious leadership, including those by President Barack Obama, Secretary of State Hillary Clinton, Attorney General Eric Holder, the U.S. Department, U.S. embassies abroad, and the U.S. military commander in Afghanistan, General David Petraeus. I remember being both shocked and appalled when the Secretary of Defense, Bob Gay, personally called Terry Jones to intimidate him. Yet just last Friday, a senior defense official visited a Virginia mosque to give a mea culpa on behalf of the armed forces for the alleged Quran burning by troops in Afghanistan. Who knew that the Quran burning deserved the same level of attention from DOD as Russia's nuclear arsenal? But actually, under the current administration, it's probably a priority over such mundane issues as weapon defense. Following another report from Andy McCarthy just last week, a Pennsylvania state judge admonished a victim in court during a hearing who was assaulted by a Muslim man during a Halloween parade last October. The victim was an atheist who inexcusably, in Magistrate Judge Martin's view, wore a zombie Muhammad costume in public, and the charges against the Muslim man were dismissed. Judge Martin said, here in our society, we have a constitution that gives us many rights, specifically First Amendment rights, but it's unfortunate that some people use the First Amendment to deliberately provoke others. This ruling, along with other state court rulings across the country, exposed the growing censorship of free speech in our courts in deference to Muslim sensibilities and Sharia law. While the federal bureaucracy through the State Department, Justice Department, FBI have all institutionalized regulations that, quote, promote Muslim sensitivity and essentially endorse Sharia, the Islamists are also amassing unforeseen victories through the court, both through legal jihad and Sharia defenses. To many Muslims, Islam is simply their private religion. Unfortunately, a notable segment also view Islam and Sharia as a culture which takes legal and social preference over their civic responsibilities. We must remain vigilant in defending our republic's founding documents and principles against the threat of Islamic lawfare through policy proposals, advocacy, public awareness, and the democratic electoral process. This is our duty as concerned citizens. Just think of the state of mind of our country on 9/12/01 and where we are today. Thank you.
Sam, thank you. Obviously, the quick consensus I assume you're forming is the First Amendment seems to be under fire politically, legally, and culturally. Quick program note before we get to your questions, and we're not surprised this has happened. We're going to shorten up this break that we were going to have to allow more time for questions and more time for the next panel. So here's what we're going to do. We'll have questions until about 10:15, then we'll take a short break. If you want to leave now and get a snack or something, please do, but we'll come right back at 10:20 and start up with Frank's panel. So With that in mind, let's start taking questions from the audience. Do we have a handheld mic for people in the audience? But we can probably hear you, so.
We'll try to repeat the question if you want.
I can repeat the question. We've got a question over here, so you want to just.
Yeah, I'm Bill Gertz. I'm associated with the National Security and New Media Project as well. You've identified the problem fairly well, the idea that if radical Islamists are misusing the First Amendment, misusing the law, and misusing the ideas of religious liberty and freedom. The next question is, what do you do? How do you counter this? It seems to me that one way would be to do counter lawfare and to sue these groups. Another would be, obviously, congressional legislation. My experience working in Washington is that when things are in law, it's really what spurs the administration to do things that they don't want to do often.
So, next steps.
Yes, I think that countering lawfare is extremely important. I think that there are a couple things we can do. Number one, and I'll mention this again, we have to encourage people to exercise their rights. There's no point in having the First Amendment if people aren't going to take advantage of it. So, I moved here from Canada because I have a great respect for the United States Constitution, and yet it saddens me that every week I get a call from an American blogger or a filmmaker asking me, literally, is blasphemy a crime in this country? People are not educated as to what rights they have under the First Amendment. The other thing in terms of lawfare in the international arena, the fact of the matter is there's no due process in international law. We have, a Human Rights Council that had Libya as a member. We have a Commission on the Status of Women at the United Nations that Iran is a member of. These things should delegitimize the Human Rights Council resolutions coming out and should undermine their authority as customary international law. I think it's super important, I think Sam can speak about this, to create escrow accounts for victims' funds so that when people are sued, their litigation costs, their court costs are taken care of, and that they're hooked up with attorneys who can defend them, hopefully on a pro bono basis. And then the final thing is to go on the offense. Lawfare is more than just filing lawsuits to silence free speech. It's also about undermining state sovereignty and frustrating our ability to fight and defeat terrorism. We see lawfare in the Goldstone Report, a politicized document that attempts to take away Israel's right to self-defense. We see lawfare in the ICJ, International Court of Justice advisory opinion, saying that brick and mortar, a security fence, is a crime against humanity. All those bad precedents in international law have to be reversed. We have to take back international law. We created it.
Anybody else?
Yeah, I guess I sort of come at this from the opposite end, Bill. I think that the problem is too much law, and what has to happen is that Congress needs to remember that part of the Constitution that puts it in charge of the jurisdiction of the courts. If you enacted laws that said that it was the following, and this isn't just a Islamist ideology problem. This is a problem with a variety of things which the courts have sort of intruded themselves into that they initially had no business being involved in. But Congress can use its authority under the Constitution to limit the jurisdiction of the courts and to say that this or that subject matter is not the business of the courts. Understand that when you allow the most important decisions that we make as a political body to be decided by the courts, you're transferring them to the branch of government that's not accountable to the people, and that you can't fire if they get it wrong. So what we should be trying to do is moving these things away from the courts, removing the ability of the courts to make policy, and returning it back to the political arena where most of these issues, I think, cut about 75% to 25% if you bring them back to allowing, to the way we see it. If you bring it back to allowing a self-determining people to actually determine for itself. But if you're going to transfer authority to the unaccountable branch of government, which happens to be the most elite, progressive, unaccountable, unattached to the to bourgeois values branch that you have in government, then we're forever going to be in this situation where things are being imposed on us and where we're not really in control of our own destiny.
Did you want to say anything, Sam?
Sure, I would just say I agree with both Brooke's strategic advice and Andy's sentiments. One piece of legislation that the Legal Project has discussed is using something along the lines of the FACE Act, which was passed in 1994 in order to protect abortion providers, and would give you be able to get immediate civil damages against any possible threats, and any threats. While it doesn't seem likely under the present Democratic Senate, we've discussed it with some House members already, and they seem open to the idea, but we'll have to wait.
Let me just follow up with a quick thing before we take another question. Do you think it makes sense for Congress to send a message to the administration to perhaps withdraw from the Istanbul process, based on what you've said, Brooke? And
yeah, I think the Istanbul process is flawed. We have no business there. I mean, the cornerstone, I learned in law school, the cornerstone of liberal democracy is the right to speak freely and critically about government and religion. And yet our government, in my opinion, is violating the First Amendment by co-sponsoring Human Rights Council Resolution 618 that calls people like me and Andy and Sam extremists. It's a trap, this process.
Yeah, well, I'm delighted to be an extremist on this, and I'd also add though, just think about this for a second. Why is Gitmo still open? Why wasn't Khalid Sheikh Mohammed tried down the block? Right? It happened because the American people got outraged by some of the things that the administration had as priorities when they came in, and they lit a flame under Congress. And Congress cut off the money for the administration to be able to pursue the things that they wanted to pursue. That's how things get changed. They get changed from the bottom up politically. But, you know, if they're going to continue to get changed from the top down by legal institutions, we are not going to like the changes, I can assure you.
Okay, let's take some change. The gentleman right there had his hand up first.
I'm Stuart Kaufman of the United West. One very minor admonition to Bill Gertz. You referred to radical Islam. In fact, the behavior of jihadists is normative Islam. And I just wanted to make sure that that didn't go unmentioned, because that's one of the problems that we have, is understanding how to define what Islam is in order to be able to fight those who would impose Sharia. At any rate, one of the things that, I don't remember if it was Andy or someone else who talked about staying out of the political process, and obviously a lot of the institutions to which we ascribe are 501c3 organizations and can't be involved in politics. But isn't that one of the problems? The fact is that although lawfare is a significant issue and must be combated with, I believe, institutions such as Frank and David Yerushalmi just established, this new law firm, in order to fight this kind of thing. But isn't the problem, in fact, the political process and those who are now in charge in Washington? And how can we mobilize ourselves to fight the acceptance of Islam as a religion which is protected rather than as a political system which we have to reject?
Good question. Good question.
I think a big mistake that we've made, and I think we're somewhat responsible for this, those of us who were there at the beginning dealing with this as a terrorism issue, is that our tendency is to talk about it in terms of clash of civilizations and the sort of thing that that rubs a lot of the convincible people who ought to be our natural allies in this struggle the wrong way. I mean, it basically turns them off instantly. And what I think we need to bring this down to, and it's all an educational process, I think, more than a legal process, is the rhetoric of civil rights rather than the rhetoric of clash of civilizations. I mean, think about Sharia that they want to impose. Basic elements of Sharia. They reject the the right of people to make law for themselves irrespective of any religious code. They reject equality between men and women, equality between Muslims and non-Muslims. They reject our notions of private property. They reject our basic notion that we resolve our disputes in a peaceful democratic process. There are 4 or 5 or 6 core elements of Sharia that are absolutely antithetical to American constitutional republicanism. And if you talked about this as a civil rights issue rather than a religion issue, and you forced people who wanted to impose Sharia to defend inequality and defend the idea that apostates should be subjected to the death penalty, or that homosexuals should be killed, or that people who engage in sex outside marriage should be killed, or that private property, you can't have accumulations of property, or that you can't charge interest. I mean, make them defend this. And then it's a civil rights issue, not a clash of civilizations issue. By the way, I'm not contending, I actually happen to believe that the clash of civilizations narrative has a lot of merit to it. But the fact is, if you're going to try to talk about a practical political strategy to have people on our side who ought to be on our side, then you turn this into a civil rights issue, and I think we would do better with that than we've done.
Thank you. I'll take one more. Patrick, do you want to ask something?
The question is really directed for Andy. What are the potential implications of the new form of lawfare we're seeing, i.e. the marriage of agenda-driven journalism protected by the First Amendment and lawsuits targeting intel and counter-intel operations like we're seeing with the Associated Press and the NYPD presently?
Well, you know, I think probably Brooke and Sam have probably followed the specific litigations closer than I have. Let me just say, and maybe you guys could address that better than I can. I would just say, as a general matter, again, I think what we need to have happen here is Congress cut the legs out from underneath the people who were bringing these lawsuits by denying the jurisdiction to bring them. And that, I don't think, is something that's usefully done on a case-by-case basis. I think that if you educate people to this and you have the public will to have Congress do this, it ought to be done in one fell swoop. And that would be a huge advance. But as far as the specific litigations are concerned, you guys probably follow them closer than I do.
Well, yeah, I mean, there's the chilling effect, there's self-censorship, there's Islamophobia accusations, but I wanted to mention, I think Sam was alluding to that one piece of legislation, a federal version of an anti-SLAPP statute, SLAPP being strategic litigation against public participation, and what that would do, Congress would provide a preliminary motion to dismiss the case if you can show that the plaintiff is just maneuvering within the legal system, wasting the court's time to silence your exercise of your First Amendment rights. And that would, I think, minimize the cost. And I just also want to mention, Andy's point, expose the people who are Sharia adherent, is a very good one, but we have DOD, for example, working directly against that. Look at what happened at Fort Hood. They omitted the fact that Major Nidal Hassan had jihadist sympathies. He was an adherent to Sharia law. He wrote, I think it was an essay calling for the painful liquidation of non-Muslims and justifying suicide bombing. And now DOD says it's workplace violence. This isn't Sharia-based terrorism. This is workplace violence. So there is an active effort on behalf of the administration to, dumb down the dialogue about what people, Sharia adherents, actually believe in.
I just want to say quickly that I read over CARE's complaint. It's an equal protection violation complaint against the NYPD for surveilling Muslims for national security reasons. And it's going to be, it's interesting to see how the decision will be. Depends on, unfortunately, the judge. I think you could agree with that, right? Yeah. But the implications are far and wide, and I think it goes back to what I said of where we were on 9/12/01 to where we are today. And I think with Muslim sensitivity training throughout the government, as Mr. Gaffney has talked about, we're in a major strategic problem.
Well, on that, I think we better wrap up this panel. Let's give our panelists a nice hand. We will take a short break, give you just enough time to buy Brooke's book and Bill Gertz's book, which is also on sale in the lobby, and then we'll be back here in about 5 minutes to start the second panel. Thank you.